Mr. Kavanagh.
May it please the Court, I've just had 3 more points to make, if I may, before I leave the European law issue. And they are these. May I invite the Court to pick up Christie, which is in Authorities Volume 1, tab 5, because an argument not identical to the argument for this Court, but a similar argument was raised on that occasion.
Sorry, could you just repeat the
Yes,
reference?
Volume 1, my Lord, tab 5, and within that it's paragraph 36 of the judgment, which is on page 1563. Having dealt with, in the previous section, which I won't take the Court through, to whether there was an autonomous meaning of worker for the purposes of the directive across Europe, Mr. Justice Elias then went on to whether the exercise of the discretion was exceeded in the circumstances. And Mr. De Mello, counsel for Mr. Christie, had relied upon the Adenela case on the basis that if there is a discretion, it's fundamentally undermined if part-time judges are excluded. And Mr. Justice Elias then looks at the judgment in Adenela, paragraph 37, and particularly the passage in which it says that while member states have a margin of appreciation, in fact that wasn't in relation to the meaning of worker. That was in relation to whether it was all right to allow successive contracts if more than 20 days elapsed between each. Yeah. But nevertheless, it was submitted now at the top of page 1564 that the exclusion of judges fails to guarantee the result imposed by the directive. Mr. Justice Elias rejected it, saying that Clause 2 plainly envisages that the member state can, at least within limits, determine the scope of the agreement, that it would negate the effect of that provision to assume that there was a concept of worker which had to be adopted, and then to assert that any departure from that concept would undermine the protection afforded by the directive. That the directive gives protection to those who are defined as relevant workers under domestic law. There will necessarily be some limitation on the extent to which member states can define the relevant concept, otherwise it would in effect entitle them to contract out of the purposes of the directive. But there is, in his judgment, reasonable leeway which member states are accorded, and that's supported by the observations of the Advocate General in Vippel. Adelena is very far removed from the circumstances envisaged here. That involved passing a law which, on the facts, the court held did significantly undermine the protection of the statute. Here there is a minor limitation excluding a certain limited category of part-time judicial officers. The exclusion is of a fundamentally different nature to that in Adenela. Clause 2 of the agreement plainly envisages that some categories which might be thought to fall within the broad definition of worker can be excluded by a member state. If that premise is correct, as I think it is, then this exclusion seems to me wholly consistent with the discretion given by the directive and the agreement to member states. And all I seek to do is respectfully invite the court to adopt that reasoning, which I hope is similar to the submissions that I've been making to the court this morning. And plainly, well, it may not be plain, but it is the case that Del Quero Alonso wasn't put before Mr. Justice Elias. I don't know, in fact, whether even judgment was given in Del Quero Alonso before then, but he was plainly considering a line of argument similar to the line that's been advanced by Mr. Allen before this court.
I'm not quite sure what principle he's applying. Really, is it just that, well, this is a small number of people, and therefore it doesn't matter very much, or is there more in it than that?
Well, again, I think it comes back to my respectful submission that whilst one can see that there are difficulties of knowing where the boundaries of the discretion of the leeway given to the member state come, and that might be a real difficulty in other cases, it's our submission that that's not a problem in this case, because if one is permitted to have exclusions at all, then an exclusion which covers people who have historically, as a matter of law, not been regarded as workers or people with employment contracts or employment relationships in the law of the member state, who are substantially different from the generality of workers, then wherever the boundaries are set, this case comes within them. I know that's not a complete answer to my Lord's question, but that, in my submission, that's the analysis that Mr. Justice Elias adopted.
Well, he was really very much guided by paragraph 45 of the Advocate General in Whipple, and he doesn't really get very much help from that, because he's told there that it's a very wide discretion, and as regards limits on that discretion, it's only the very broadest limits can be determined in this respect by reference to community law, whatever that's supposed to mean.
Yes.
So he didn't really get very much help.
No, and I can't pretend there is a vast amount of help to be derived from it, save, and I apologise, but I keep returning to these two, in my submission, of fundamental and clear propositions, which is that there is no autonomous and uniform European meaning, and if that's right, then it must mean that there is leeway, as Mr. Justice Elias put it, for the member states to define worker in such a way as to exclude certain people. And if that's right, then judges must be within the category of people whom it is legitimate to exclude.
That would cover judges as a whole, of course.
I beg your pardon?
That would cover judges as a whole.
It would. Yes, I think that must follow from my submission. May I move on to the second of the 3 points as swiftly as I can, of course, subject to any questions my lords and my lady might have. It's about the INPS, or Bruno and Pettini case.
Yes.
You will have seen, I hope, from our case, which was written at the time when only the Advocate General's opinion was available, that we respectfully submitted that it had no relevance because it deals with a completely different issue concerning what is known as vertical part-time workers, people who work all day but only some days, rather than some of the day and all days, who are regarded as horizontal part-time workers. The Advocate General had to consider whether discrimination between different types of part-time workers, all of whom were workers within the directive, came within the scope of the directive, but the court in the event didn't feel it necessary to express a view on that point. The passages that my learned friend relies upon in that judgment, which are paragraphs 30 to 32 of the judgment, unless the court wishes me to do so, I won't take you to them, because my point is a very basic one, come in a part of the judgment where once again it was argued that the part-time workers regulations don't apply to pay. They only apply to employment conditions in the narrower sense. That argument had been advanced and had failed several times in relation to the fixed-term workers regulations. It was equally unsuccessful in relation to the part-time workers regulations. But it's that context in which general comments are made about the fundamental nature of the rights that are afforded by the fixed-term and part-time workers regulations. What it doesn't do is purport to examine the meaning and scope of Clause 2.1. And for that reason, unless the court wishes me to do so, I won't return to it.
You?
The last point that I just felt I ought to make, it's more a point of clarification rather than a submission, is that the court should, and no doubt is aware, that in addition to his part-time workers claim, Mr. O'Brien has an equal pay claim that he issued in the same set of proceedings, but which has not yet been dealt with. And that is relevant only insofar as some of the submissions, particularly perhaps from the Council of Immigration Judges, seek to equate a part-time workers claim with a claim for equal pay or a claim for sex discrimination. In fact, they're separate, and you can, there's no impediment, even if the part-time workers regulations don't apply, to a person bringing a claim under the Sex Discrimination Act or the Equal Pay Act if he or she feel that they come within it. I'm sorry, I'm just looking for the citation that I can give the court of the passage in the bundle where it can be seen. And I'm sorry, I'm failing to manage to do so. But The position is that the originating application included two claims, claim for equal pay and a claim in relation to, obviously, the part-time workers regulations. The claim for equal pay was left behind because the part-time workers claim originally started off as an issue in relation to time limits, and there wasn't a time limit issue in relation to equal pay claim. When and if the court has the opportunity to look at the originating application, it will be seen that actually Mr. Sorry? Thank you. It's in the appendix, volume 2 of 2, at pages 13, or at page 13. But it will be seen that Mr. O'Brien's actually claiming that it's sex discrimination against men. That is the basis upon which he can claim indirect discrimination for the purposes of the Equal Pay Act. He's not suggesting, therefore, that there's something inherent in the way that part-time judges are treated, which amounts to sex discrimination against women. And it's perhaps not entirely surprising that there's been no enthusiasm to proceed so far with the equal pay claim on his part.
You say that Bruno and Pettini we needn't really bother about, and I see why you say that, but it is quite interesting because it was about pension rights, and part-time judges are what, in the terminology there, employed vertically part-time, aren't they?
Yes.
So that it is, in that respect, it's similar to our case.
Yes. So certainly there wouldn't be a jurisdictional objection.
Apart from the pilot project proceeding at Croydon at the moment, where judges are sitting either in the morning or in the afternoon trying different cases.
My Lord, all of that is right. So we don't have an argument that simply because it's a vertical relationship, that would take it outside the scope of the regulations. There are other arguments, obviously, that if we fail on the jurisdictional issue would come to life, one of which is whether, if the real reason for the exclusion is because of the fee-paid nature rather than the part-time nature of the work, it's discrimination on the grounds of being a part-time worker. And that's an issue which there's an EAT authority against us at the moment, not in relation to judges, but that is potentially a live issue if this case were to go further. My Lords, may I move on then to deal with the what I've described as the domestic law point, the status of judges in English law. And if I can just describe to the court the sequence of submissions that I'll make, if I may, in the time available. I'm going to begin with a few observations, partly arising out of questions from the bench to my learned friend yesterday, about whether judges should have contracts. I'm then going to focus upon the Percy judgment and deal with the guidance that's given in that judgment by various members of the House of Lords. I'll then very briefly deal with some of the other authorities and the other points that are made against us, for example, in relation to VAT by my learned friend, but I hope I can deal with that relatively briefly. And then really, the only other things that I have to do are to address, if I may, the issue of, if you are minded to make a reference, what the terms of the reference should be. And we have an alternative formulation, which we emailed to my learned friend last night and which we'll hand up to the court in due course, and also some general observations to make about the schedule that they've helpfully drafted at the end of their case. And though I say it's helpfully drafted, you may not be surprised to hear that we don't think it's entirely of a form that's appropriate to be transmitted to the Court of Justice, but that's the broad sequence of the submissions that I'm proposing now to make. So beginning then with the question of whether judges have an employment contract or a contract for services as defined in Clause 2.1 of the regulations. The definition has two limbs to it, of course. In 2.1, there's 2.1a, which is the employment contract in the strict and narrow sense, and 2.1b, which is what is generally referred to as a contract for services, except not a business relationship or a professional relationship. So I don't have a contract with the Treasury solicitor, even if I have a contract at all. But the wording, if one reads across from the wording of the directive, we would respectfully submit that the directive refers to an employment contract or employment relationship as described, as defined in the law and practice of the member state. We would say that the first limb of clause 2.1 is the definition of the employment contract. The second limb of it is the definition of an employment relationship. But if we are right on our submissions on European law, and as was noted in the handout that we gave in at the beginning this morning, we respectfully submit that there is no reason, based upon European law, why it's necessary to provide an expansive interpretation to the meaning of employment contract or contract for services in order to bring domestic law into line with the directive. But the primary case of our learned friends, as we understand it, is that judges have a contract of employment. Because that's what they say in paragraph 117 of their case. As it was developed, as we understand it, what my learned friend was really saying is that because the characteristics of a judge's relationship with whoever it may be, the Ministry of Justice or the Lord Chancellor, have similarities to the characteristics of a contract of employment, that means it is equivalent to an employment relationship for the purposes of the regulations and the directive. In our respectful submission, taking first the authorities of Waters and Miles and Wakefield that my learned friend drew the court's attention to yesterday, those really don't go very far at all. The Waters case, which was the case about the Metropolitan Police officer, the sexual harassment case, simply, as my Lord Sir John Dyson pointed out, was a strikeout case, but also, in the course of it, it was acknowledged by the Court of Appeal that there was no contract of employment existing between the constable and the Commissioner of Police. That, for the court's note, it's in Bundle 2, document Authority 38, page 167 at letter E. So actually all one gets from Waters is that police officers are one of that class of office holders who don't also have a contract. As for the Miles and Wakefield case, the case about the Registrar of Births, Marriages and Deaths, I hope again I can deal with this very briefly, because that was a case in which, as my learned friend Mr. Allen made clear yesterday, it was conceded on behalf of the claimant that he didn't have a contract. The question was whether he had an honorarium entitling him to be paid, regardless of whether he performed any services or not, and whether the law relating to industrial action that applies to employees applies similarly to office holder. In our respectful submission, it has nothing to tell us about the issue of whether judges have contracts of employment. Nor in our respectful submission can any conclusions be drawn from the undeniable fact that judges and part-time judges are remunerated for the services that they provide, because that is provided for in section 21 subsection 7 of the Courts Act 1971, which is in Bundle 5, tab 91. So in our respectful submission, if in the inconceivable event that a judge wasn't paid, as they should have been paid, for a period of sitting, their remedy would be a claim for breach of statutory duty. It wouldn't be necessary to give them a contract in order to give them a legal remedy. And I hope it follows from that submission that we're not saying, of course, that there is no legal relations between judges and the state. Rather, we're saying that it's not an employment relationship, not a contractual relationship. And I won't, if I may not interrupt the flow of my submissions now to take you to it, but I will, when we come to look at Percy, show you paragraph 62 in Lord Hoffman's dissenting speech, in which he makes the point that gives judges an example of office holders who do have legal relations, but nevertheless don't have a contract. Position's completely different from Miss Percy, of course, because the contention on behalf of the church was that she had no legal relationship of any sort.
What's the basis for saying that the remedy, if a judicial officer is not paid, is breach of statutory duty, when, of course, the office that we're concerned with at the moment carries with it a statutory right to remuneration, but the actual rates of remuneration are fixed in a non-statutory manner?
Yes. Well, my lady, in my submission, one could interpret section 21.7, which makes specific reference to the Lord Chancellor setting the rates, as carrying with it an implied entitlement to being paid at the appropriate rate for the time.
Such rates as he sets.
Such rates as he sets. Alternatively, it may be that there would be a claim for judicial review on the basis that it would be an irrational exercise of the Ministry's discretion to pay anything other than the amount that is the
Yeah, but
amount
judicial
set for
review
time.
doesn't get you your money. That's
No, but
it's not an appropriate remedy for actually getting money out of it.
But one gets a declaration. And in my respectful submission, this is a theoretical rather than a practical problem. Judges are not, in reality, ever going to be at risk of being unpaid by the Ministry of Justice in our respectful submission. However, we respectfully submit there are a number of real problems that would arise if judges did have contracts. And they are referred to by the Court of Appeal at page 20, which is cited at page 20 of our case, which might be the easiest place to look at it.
Whereabouts in the Court of Appeal?
It's paragraphs 47 and 48, my lord.
Thank you. Yes.
It's really the end of paragraph 48. Having gone through the authorities, perhaps whilst we're here, can I just remind the court, paragraph 47, which refers to copious authority to support the proposition that a statutory officeholder such as a judge is not employed under a contract and is not in employment. None of these authorities is dispositive of that case any more than it is of this case, at this stage of this case, but they do illustrate that it would have been groundbreaking if the part-time workers regulations were to have departed from that underlying assumption. Regulation 1.2 is in language that inhabits a different terrain from that exemplified by the officeholder authorities. He then sets it out and carries on for good and obvious reasons. The purpose of that provision is to ensure that protection is not lost where the relationship is properly classified as one of employer stroke independent contractor rather than employer-employee. It does not describe the work of a judge who does not undertake to do or to perform personally works or services for another party to the contract. When asked rhetorically, what other party, what contract? And if I may follow on from those rhetorical questions that Lord Justice Maurice Kay asked himself on that occasion. There are a number of problems. One problem is who the other party to the contract would be. For example, whilst appointment is made, I think, by the Lord Chancellor, deployment of judges is nowadays a matter for the Lord Chief Justice. And there has, as the court will be much better aware than me, been a trend in recent years to separate the administrative functions from some other more operational functions in relation to the body of judges, which have tended to be allocated to the heads of the judiciary rather than to ministers or to civil servants. There is the issue of what terms the contract would contain. In the absence of any express terms beyond a term to be paid, what about the usual duty of reasonable care. That gives rise to enormous practical difficulties if judges have a duty of care in relation to the functions that she or he performs. What about the duty of fidelity that is a standard implied term into every contract of employment, together with the duty of trust and confidence that is supposed to be owed mutually by employer and employee? A particular problem when the Crown and sometimes the Ministry of Justice are parties regularly in cases before the courts. Again, judicial discipline, there's no need for judicial discipline to be the subject matter of a contract. I'm afraid it's not in the bundles, although part of the Act is, but Section 108 of the Constitutional Reform Act provides for the disciplining of judges, and that is another example of a function that has been divided between the political and the professional side of the higher judiciary. So it's the Lord Chancellor who dismisses judges, but it's the Lord Chief Justice who imposes discipline less than dismissal, such as suspension. All of these, in our respectful submission, make it extremely difficult to graft a contract of employment onto a relationship that has existed quite happily since time immemorial without a contract of employment. We also respectfully submit that if judges are to have a contract, there couldn't be no reason why police officers wouldn't also have a contract, because all the reasoning that my learned friend has given yesterday as to why judges should have a contract apply equally to police officers. It is, of course, historically, in a legal sense, been the position that police officers hold an office, the office of constable, which is not accompanied by a contract of employment. In terms of the part-time workers regulation, special provisions being made for them by Regulation 16. But was it not for Regulation 16, we respectfully submit, police officers would have been outside the scope of the part-time workers regulations as well. And that there is no good reason of law or policy why either police officers or judges should at this point suddenly become held to be covered by a contract or a contract of employment when there's no prior authority suggesting that that was the position. That was not believed or understood to be the position by anybody in the year 2000 when the part-time workers regulations were made. And indeed, in our respectful submission, the reason why there are so few authorities on judges and contracts is because it's never really occurred to anybody in the past that judges might have a contract. And that's why it's not been a live issue in very many pieces of litigation.
There's always a first time.
There is always a first time, my lady, but of course there has to be a good reason for a first time, and it's my submission, as my lady knows.
Could you just remind me, do we have the regulations which implemented the fixed term, the parallel directive?
I think we do. If we do, they'll be in tab 5, in volume 5. I think we do. Maybe. Oh, are they? Thank you. I'm told they're in the loose leaf file. No, I'm afraid they're not. My lady, they're not. If the court would like to have them, we can, of course, arrange for copies to be provided.
I expect I can manage to look them up for myself, but not instantly, obviously, if they're not in the room.
No. What I do have, my lady, is Butterworth's Employment Handbook. Or, in fact, Miss Moore has a copy. Can we pass it up?
I'd find it very helpful.
I'm also corrected that the reference to disciplinary powers in the Constitutional Reform Act is indeed in the Court's papers It's in Bundle 5, document 107, at page 46 to 49.
Yes. Yes, I see.
Unless my lady would like me to deal with something in relation to fixed term regulations, I'll move on to person.
No, I've got to find out whether I've got a question to ask you. That's why I wanted to
In
look at
that case, I'll carry on if I may. May I move on then to the Percy judgment, which of course concerned an assistant minister of the Church of Scotland. It's in volume 2, tab 24. Sorry, before doing that, may I take you to tab 23, which is Percival Price? It may be more convenient if I look at that first. Percival Price, which is at tab 23, as my learned friend explained yesterday, is a case about equal pay and sex discrimination, and therefore the comprehensive and autonomous meaning under EU law applied. The relevance for present purposes is that in my respectful submission, the Northern Ireland Court of Appeal took the view that a judge did not have a contract, was not employed under the domestic legislation, and that's relevant for a reason that I'll come on to when we look at Percy. But at page 383 of the photocopy, the third page in, at paragraph 17 of the judgment, the relevant definitions in the Equal Pay Act Northern Ireland are set out. Section 1.7 contains the usual definition of employed, but the narrower one, contract of employment. Section 1.9 contains the wider definition of Crown employment, which is not quite the same as that applies under the part-time workers regulations, but is the same as applied under the Sex Discrimination Act. The main difference is that it contained an express exclusion for the service of a person holding a statutory office, as one sees from subparagraph A. If I can ask the court then to move to the facing page, paragraph 26, having examined the meaning of worker in European law in that context, at the very end of paragraph 26, having described some of the characteristics of judges, they're not free agents to work as and when they choose and are self-employed persons. Their office accordingly partakes of some of the characteristics of employment, the servants of the state, even though as office holders they don't come within the definition of employment in domestic law. So the starting point was that as a matter of domestic law, the Northern Ireland Court of Appeal didn't think that they came within the definition of employment. The Northern Ireland Court of Appeal then went on to determine that because of the autonomous meaning at European level that applies to these provisions, they had to find a way of bringing judges within the scope of the Equal Pay Act, and they did that by disapplication of the relevant provision of the Act. But what they didn't do was do so by finding that judges were employed under a contract. One sees that at paragraph 38. The conflicting provisions in domestic law can be simply isolated. They consist of the phrase in section 1.9, the 1970 Act, and article 82.2 of the 1976 order, other than service of a person holding a statutory office. This exception is, for the reasons which we have given, inconsistent with the requirements of Article 119 of the Treaty and the directives. It has to be disapplied. That is to say, the court should, in applying the provisions of the Act and order, disregard the phrase. If we follow this course, then the applicants are included within the remaining wording of Section 1.9 and Article 82 and are entitled to advance their claims for equal pay. So, in our respectful submission, the Northern Ireland Court of Appeal was not finding that as a matter of domestic law, judges were employed under a contract, indeed quite the reverse.
But they were holding that once those words had been disapplied, then they were employed.
No, they then came within the Crown employment meaning rather than the employed meaning. They came within the Crown employment definition, which is in paragraph 18 of the judgment.
Yeah.
And they did that by applying a strained but purposive construction so as to ensure that they came within the scope of the legislation. What they didn't do in our respect for submission is find that they, even on a wider European interpretation, they came within section 1.7, employed under a contract of service. If I might ask the court to move on to Percy, which is the next tab, conveniently. My learned friend took the court helpfully and extensively to provisions of this judgment, so I won't spend time reminding the court of the facts. I know, of course, that two members of the court were in it. We don't suggest that Percy was wrongly decided, needless to say, but we do say it can be distinguished from the present case and can be distinguished in three respects. The first, and if I enumerate them and then try and develop my submissions, the first is that Percy was a case concerning a person who was not a statutory office holder, but who held an office in a much looser sense of the word, and indeed whose real status, when analysed, was that of an employee. Secondly, and this is perhaps the crucial distinction, Percy is a case concerning sex discrimination, and therefore the relevant meaning of worker in European law was the EU concept, which is, as we have submitted, an autonomous concept much wider than the meaning in the part-time workers regulations needs to be. And thirdly, the main argument advanced by the respondent in that case was that Miss Percy had a spiritual office, but no legally enforceable rights whatsoever on a human plane flowing from that office. That there was, one of the ways it was put, there was no intention to create legal relations. So putting it much less elegantly, she was high and dry in legal terms, not just in relation to sex discrimination, but in relation to any other aspect of her relationship with the church. So can I just try and support those 3 points of distinction before going on to make other submissions on Percy. As regards the first one, the looser nature of the relationship, that's illustrated by a passage in Lady Hale's speech at paragraph 148. Sorry, I'll give you the page reference, which is page 175.
Sorry, which paragraph is it?
148, my lady.
Thank you.
My lady had said in that case that in any event Miss Percy was clearly not a statutory office holder, and she also doubted whether her particular post fell within the classic common law definition of an office, as set out, for example, in the Beta case, of a subsisting permanent substantive position which had an existence independent of the person who filled it, and which went on and was filled in succession by successive holders. And nor, as Harvey puts it, was she a person whose rights and duties are defined by the office she holds rather than by any contract. Her rights and duties were defined by the terms she had agreed with the parish reappraisal committee, which bore the hallmarks of a contract. And then my lady says that it impossible to conclude there was no intent to enter into legal relations. Our first point is simply this, that the type of office that it was said that Miss Percy had was completely different in its nature from the type of office, statutory office, well established over very, very many years, that a judge has. Indeed, as my Lord Hope had pointed out at paragraph 127, on the top of page 169, she was being asked to work for and under the direction of the parish minister. And I fear I've got the wrong reference because I can't see it in there.
It's paragraph 127. In the appeal cases, it's page 66.
It is 127.
127.
Yes, I'm sorry, it is in
It is,
127
it
on
I
the
think so.
ICR's
Letter H.
letter H. Indeed, so, my lady. 127. So she was really, in our submission, an employee in all but title, and therefore in a very different position to the position of a statutory office holder. The second point of distinction that I mentioned perhaps doesn't justify elaboration. It was a case of sex discrimination, and therefore the autonomous, uniform and comprehensive meaning undoubtedly applied, as was recognised, of course, in the courts, in their lordship's speeches, my lady's speeches. But coming to the third point, the argument as it was advanced in Percy was that Miss Percy was left completely high and dry. That's recognised, for example, by Lord Nichols, paragraph 26 of his speech in the ICR at page 143.
Paragraph?
126, my lord.
I think most of us are probably looking at the appeal cases version.
I'll try and use the references from that from now on, my lady.
It's the phrase intended to have no legal effect.
Yes.
Is that it, really?
Yes.
It is my recollection, and no doubt my Lord will correct me if I'm wrong, that apart from the effect of the Church of Scotland Act, the principal argument which was being advanced on behalf of the Church was that there was no intention to create any sort of legal relations, rather than the sort of argument with which we're engaged today. And of course, that was the basis on which the Court of Session had decided the case. So it's not surprising that the Church was... and there were all the other cases about the Church of England, and, well, not necessarily the Church of England, but other ministers here, which supported that.
Yes,
So-
indeed.
I mean, you can really see the breadth of the argument from the first sentence of paragraph 25, actually, because I think the point was being made that perhaps not so obviously in Miss Percy's case, but in the case of a minister, his duties were primarily religious, and really you couldn't find a contractual basis for it. It was a sort of spiritual office. And indeed, the way ministers are appointed is rather unlike the way Miss Percy was appointed. They're simply invited by a congregation to take a post as a minister in the church.
Yes.
Whereas Miss Percy actually was quite clearly under some kind of offer and acceptance situation which distinguished her from the ordinary minister.
Yes, that's a point my Lord makes in your speech, in my Lord's speech. May I just show the court paragraph 62, which is in Lord Hoffman's speech, which is on this topic. It's on page 48 of the appeal cases version.
Yes.
Lord Hoffman, who dissented, of course, because he felt that they were office holders, nevertheless agreed that there was an intent to create legal relations. He says at 62, nor do I, perhaps picking up the end of 61, the fact is that he, that is a priest, holds an office, a well-understood legal concept, which creates rights and duties but does not involve a contract of employment. Nor do I think it's very helpful to say, as was said in Coker, that a priest is not employed because her appointment was not accompanied by an intention to create legal relations. That, together with the proposition that the priest is the servant of God, gives the impression that she operates entirely outside the legal system, looking to God to provide for her. It's not surprising that the Appellant's Counsel pointed to the prosaic documents issued by the Board of National Mission, which, as my Lord said, included offer and acceptance. In the face of these documents, how can it be said that there was no intention to create legal relations? That submission seems to me unanswerable. There was plainly an intention to create legal relations, but those legal relations were not a contract of employment. They were an appointment to a well-recognised office, imposing legal duties and conferring legal rights. The nature of an office inevitably means that the procedures for appointment will closely resemble those attending the engagement of an employee. No doubt similar documentation could be found concerning the appointment of, amongst many others, judges, rent officers, registrars of births, marriages and deaths. But that does not mean that their appointment to these offices creates contractual relations. And in our respectful submission, that is a proper analysis, that just because there's an intention to create legal relations, it doesn't follow that there has to be a contract of some sort.
And we see that the difference between Lord Hoffman and the majority, specifically by reference to the speech of Lord Hope, is in paragraph 66. Because what Lord Hoffman is rejecting the proposition that she had contracted personally to execute work and labour.
Yes, indeed. And 74, my lord, as well, says something the same thing.
And I think what's said here is that if you apply the underlying rationale of the majority, the same applies here.
Yes. Well, in our respectful submission, the rationale of the majority in Percy is that there can be office holders who do not also hold a contract of employment. Can I show the court passages from the majority speeches, which I respectfully submit say that? First, the speech of Lord Nichols, whose reasoning on the interrelationship between holding an office and having a contract, we respectfully submit, was adopted by Lord Hope, Lord Scott and Lady Hale. I say with all the circumspection necessary of somebody who's telling judges what they did or didn't do. But paragraph 87, first taking the judgments of the other judges, paragraph 87, my Lord Hope, says that the holding of an office and being an employee are not necessarily inconsistent with each other, as my noble and learned friend Lord Nichols has explained. So from that I respectfully draw that the analysis of office and employment and the interrelationship is agreed between Lord Hope and Lord Nichols. Lord Scott, paragraph 137, says in his first sentence that he agrees with the opinions or the reasons given in the opinions of Lord Nichols, Lord Hope and Baroness Hale. And my Lady Hale, on the facing page at least of the ICR, paragraph 140, says that she agrees for essentially the same reasons as those given by Lord Nichols, that the appeal should be allowed.
And as my Lord Clerk says, the essential point was whether the arrangements fell within the definition of a contract personally to execute any work or labour.
Yes, I don't seek for a moment
that's what the ratio of the
challenge
case
that.
is.
And indeed, as I respectfully submitted, we don't seek to either challenge that as being the ratio or dispute that it's right as the ratio. But there is some analysis in Lord Nichols' speech of the relationship. The point I'm seeking to get at, to put it bluntly, is that there can be office holders who do not have a contract of employment.
And it's a matter of analysis in the particular case,
Yes.
whether or not there is such a contract.
Quite so.
And what's said here is if you look at all the indicia of the, quotes, agreement, unquote, then it's on the contract side of the line, while also being on the office holder side of the line. That's the case now, in a nutshell.
It's quite interesting to see in paragraph 52 the basis on which the First Division reached the opposite view, because you can see it being said that her appointment was to a recognised form of ministry within the Church. The duty is essentially spiritual, therefore no intention that the arrangements would give rise to obligations enforceable in civil law, therefore not contractual. So it was very much related to a view as to the nature of what she was being asked to do. And this is a great sort of conundrum in the whole case as to whether we were dealing with spiritual issues or civil issues. And you can see how the court, how the House of Lords disagreed with Lord Roger on that point.
My Lord, yes. But in relation to the issue as my Lord Clerk has identified it, we respectfully say that there is still possible for there to be offices which are not also employments, even though they involve work and even though they involve remuneration. and we say...
Yes, I mean, this case is certainly not authority for the proposition that it follows from the fact that you're an office holder, that you're also an employee who have a contract of service or services.
No, that's my submission. And we say that there are two categories in particular which have always been regarded as pure officers, if I can put it that way, police officers and judges. In each case, it's the result of the particular independence that their office commands or should involve, and that has worked perfectly well through the ages as a legal structure within which the office is held, and that there has been no suggestion hitherto in any of the authorities that judges also have a contract, and that if we're right on the European law issues, there is no need to strive to find that judges have a contract in order to bring them within the scope of the part-time workers regulations, or indeed for any other purpose. But I'll deal, if I may, very swiftly with the relevant part of Lord Nicholl's judgment or speech, because it really doesn't go any further than the point that my Lord Clerk identified, which is that there can still be offices that are pure offices. But at paragraph 15 of his judgment, of his speech, I should say, 15, he says that the distinction between holding an office and being an employee is well established.
We have already read all this.
I'm so sorry, my lady. In that case, I'll cut to the chase. Paragraph 21, he cites a passage from the judgment of Mr. Justice Slynn in another church case, Barthorpe, in which the learned judge said some office holders may well not be employed under a contract of service, and after setting it out, Lord Nicholl says, I agree. So really the two things that I seek to derive from Percy are, one, that it is not authority directly in point that judges must have a contract, because the reasons why Miss Percy was held to have a contract do not apply here. And secondly, that it was recognised in that case that there are some office holders who don't have a contract of employment. But there is one other thing I ought to do, which is to face things that are said in the speech of my lady, Lady Hale, observations that are made, obiter, I hope I'm right in saying, in relation to the position of judges. So can I just remind the court of those? Paragraph 143. My lady refers to the relevant provisions of the Equal Pay Act and the Sex Discrimination Act, which, as has already been observed, they're set out immediately before, halfway through 143, excluded any person holding a statutory office. And after setting out that passage, my lady continued that the identical provision said the same in the Equal Pay Act. Thus, while civil servants were included, statutory office holders were expressly excluded. However, the Northern Ireland Court of Appeal, that's in Percival Price, held that the express exclusion had to be disregarded because it was inconsistent with the terms of the Equal Treatment Directive. Common ground that the directive had direct effect and that the departments responsible were emanations to the state. Hence, the women concerned had directly enforceable claims if the directive had been infringed. There was no appeal to this House against that decision. There were two necessary ingredients in the decision which are directly relevant to the case before us. The first was that without the express exclusion, those office holders would have been covered by the definition of employed in section 1.7 of the 1970 Act. I fear I must respectfully submit that's not quite right, because in Percival Price, was it not for the express exclusion, the office holders would have been covered by the definition of Crown employment in section 1.9 of the Equal Pay Act. And therefore, it's not right, if I may respectfully say so, in the last sentence of that paragraph, to say that the court in Percival Price regarded judicial office holders as employed under a contract personally to execute any work or labour. Indeed, as I hope I've sought to show the court, in fact, they found the opposite, that as a matter of domestic law, they were not employed under a contract personally to execute any work or labour. I don't, of course, seek to invite the court to conclude that Percy is binding authority in my favour. All I, as I hope I've made clear, seek to do is to show that our submissions are consistent with it. Put it no higher than that. My Lord, may I come back to, for once, following the sequence that's in our written case, in terms of our submissions as to whether judges have contracts. And because it's in our written case, I can deal with it very briefly, I hope, in oral argument. At paragraph 31 in our written case, we deal with the points made in relation to taxation by my learned friend, and I hope I can deal with this very briefly. But it's this: under the income tax Schedule E arrangements, you have to pay tax on any office or employment, and so it's entirely neutral as to whether an office holder, such as a judge, also has a contract that a judge is paid under Schedule E. As regards the VAT arrangements, we have 2 points, one complicated and one, I hope, straightforward. So I'll start with the straightforward point, even though it's the one we make last at paragraph 38 of our case. And that is this: that if we're right in our submissions that whether a judge has a contract for the purposes of Clause 2, Regulation 2.1, is a matter of domestic law, then EU law on VAT doesn't really help. There's no need, and indeed it's not appropriate, to import concepts of VAT law into the domestic purview for the purposes of the part-time workers regulations. We also have a submission based upon the full text of Article 4 of the 6th VAT Directive, pursuant to which it said, and this is set out at page 15 of our case, that states, regional and local government authorities and other bodies governed by public law are not considered taxable persons. And we say that's broad enough to encompass the current position, which is that apart from my lady's husband, so it appears, mostly judges are not made subject to VAT.
I don't think he's alone.
I didn't mean to suggest that he was, but as we understand it, and did understand it, the general position is that judges, full-time and part-time, do not charge VAT and not required to do so. Then at page 17 of our argument, and again, I hope I can deal with this relatively speedily, we set out the earlier authorities in which it is said that judges don't have contracts. My Lord, unless the court wishes me to do so, I'm not going to go back to those authorities because
we've been fairly thoroughly through them.
The court has already been through them. In our submission, they can't be distinguished from the present case. They do say what we say they say. They say that judges have offices, not contracts. Of course, none of them are binding on this court, but that is what they say, and they are typical of the understanding of the law that existed in the year 2000 when the regulations were promulgated. And what we respectfully say, my learned friend did in this stage of his analysis was, and we put this point at paragraph 45 of our written case, he jumped from the question whether a judge has an employment relationship in European law and used that to inform his argument as to whether they had a contract in domestic law. But we respectfully submit that in light not only of the authorities but in light of first principles, judges don't have contracts and there is no need to change matters so that they do have contracts. As regards the meaning of Crown employment, which we deal with at page 21 of our of our case, Crown employment is defined in the part-time workers regulations as employment under or for the purposes of a government department or any officer or body exercising on behalf of the Crown functions conferred by a statutory provision. I think it's the submission of both parties in this case that regulation was there, and it's quite common to see it in employment legislation. It's in the Employment Rights Act 1996, for example. It's there to make sure that nobody doubts that civil servants have a come within the protection of the relevant part of the legislation. But we respectfully submit it's not apt to describe judges because they do not function under or for the purposes of a government department. We set out the argument in writing in pages 21 and following, and we refer to a number of authorities, which, again, unless the court wishes me to do so, I won't take time out of my oral argument to take the court to. But in paragraph 55, we refer to two authorities about police constables, which in our submission are quite helpful because they emphasise what has hitherto been regarded as the fundamental principle in common law, that police officers have an office and not an employment. May I just give the court the bundle citations for the two cases?
Yes.
Ex parte Blackburn is bundle 2, document 31. That's the well-known case in which the Metropolitan Police were judicially reviewed because they weren't cracking down on illegal gambling dens. And then there's the Perpetual Trustee case, the New South Wales case, which is perhaps the clearest authority in our favour, but I've set out in paragraph 55 the key sentence that a police officer's authority is original, not delegated. It is exercised at his own discretion by virtue of his office. We respectfully submit that exactly the same could be said of a judge. There are a number of authorities.
The reference you're going to give
I'm
us.
so sorry, I felt it's volume 1.
1-1.
I do apologise.
Thank you.
We then set out some other authorities that are based on the sex discrimination legislation, but which was at the relevant time identical, save that there was an express exclusion for persons holding statutory office. And can I give the court the citation for those as well? Knighton Attorney General is in volume 1, tab 14. Department of Employment and Fox is in volume 1, tab 6. And the submission that we make is much more elegantly put by the Court of Appeal in paragraph 49 of its judgment, which we set out at the top of page 25 of our written submission, that it would be wholly inimical to the independence of the judiciary if any judicial office holder were to be discharging his judicial functions under or for the purposes of a government department or any officer or body exercising functions on behalf of the Crown. And similarly, in Christie, which is in Bundle 1, tab 5, Mr. Justice Elias said was weighty authority that a statutory office holder is not acting for the purposes of a government department or officer of the Crown. And again, we respectfully repeat that it's not necessary to apply a purposive or strained construction to that phrase in this context if we're right that European law has, so to speak, delegated to domestic law the meaning of employment contract and employment relationship in this context.
How does that submission sit with what was actually done in Percival Price? Because in Percival Price, they excised the words other than the service of a person holding a statutory office, thus leaving in the words service for the purposes of a minister of the Crown or government department. And the Court of Appeal in Northern Ireland obviously thought that that was sufficient. Well, either I'm right, or if you're right, they thought that was sufficient to bring these judicial office holders within the scope of the EPA.
Yes, my lady, the answer in my respectful submission is this, that if the starting point is that European law mandates the domestic law, the domestic legal system, to include judges within the scope of the definition, then by applying the very broad tools for purposive construction that a court is allowed to bring to bear on domestic statutory language, you can read Regulation 12 in such a way as to cover judges. That's what Mr. Justice Elias did in Christie itself, whilst he took the view, as I've just indicated, that actually giving Regulation 12 its ordinary and normal meaning, it doesn't cover judges. If you absolutely had to bring judges within the scope of the directive, within the scope of the regulations, the way to do it would be to read Regulation 12 in a slightly distorted way, in accordance with the teleological approach of purposive construction to bring into line with EU law. You would also disapply Regulation 17, and there you would manage to accomplish it.
That's very interesting, isn't it? Because that's a much more complicated exercise than the Court of Appeal in Northern Ireland thought it was doing in paragraph 38 of its judgment. They thought all you had to do was to excise certain words and then Bob's your uncle.
My lady, yes, but one doesn't know, or I don't know at least, exactly what submissions the Court of Appeal Northern Ireland received in relation to the relevant provision, because, of course, under the Sex Discrimination Act, there was an absolute bar in the way of judges, which is the exclusion, in those days, of statutory office holders. And that was the focus of the analysis of the Northern Ireland Court of Appeal.
It looks as if they didn't really think of the point.
That's what I'm trying politely
That's
to say.
what you're trying to say, isn't
yes.
it?
Yes, and it's never their fault, because Council no doubt didn't make submissions about it.
Would it be hugely contorted to say that the Crown Court was a body exercising on behalf of the Crown, which is the fountainhead of all justice, functions conferred by statutory provisions? I mean, it's not easy, but it's possible, isn't it?
Well, my lord, I don't suggest that Mr. Justice Elias was wrong, that if you are required by European law to find a way to construe Regulation 12 in accordance with the directive, it would be possible by a strained means to bring judges within it. But I do respectfully submit that the ordinary and better meaning in domestic construction, this is now coming to your question, is that no, that Crown Court judges, the point is that the judges don't act under or for the purposes of the Crown Court or any other, or the Ministry of Justice or the Lord Chancellor or anybody else, because it's the very essence of their being is the independence of their function.
Under the Crown.
Under the Crown,
Under the
yes.
Crown.
We act for the Crown.
Just that the Crown has several hats.
Yeah.
But nevertheless, I'm hesitating because it depends, of course, how one defines the terms as to how the submission goes. But if I'm right that the fountainhead of a judicial function is independence, then actually what the Crown has done is given priority or primacy to the judge to exercise her or his function in a particular case on a particular day. So it's no more than a legal fiction to say that it's the Crown sitting up there on the bench when they're doing the summing up or passing sentence or whatever else that they happen to be doing. May I have a moment? Yes, thank you. The point is just being made to me that in Percival Price, which is tab 223, paragraph 26, at the top of the right-hand column, the Northern Ireland Court of Appeal does refer to the need to construe the term workers purposively
Yes.
in order to get to the
Yes.
end point that it seeks to get to.
I mean, if you were wrong on the other part of the case you've been arguing so far, what should happen?
Well, if I'm wrong on the other part of the case, so that there is a obligation on the UK to include judges within the regulations, then the way in my submission that it can be done is to find a construction of Regulation 12 that encompasses them, and then to disapply Regulation 17 on the basis that the direct effect, that the relevant part of the directive has direct effect, because impacts as it does. And one of the tools that the direct effect of directives gives a member state is to disapply an offending provision of domestic legislation if it is in relation to a claim against the state authority, which of course the Ministry of Justice is. Would you agree that that's the way it can be done?
Sure, that can be done that way.
Yes. So
One probably wouldn't bother to worry too much about it.
So, in a way, I'm answering a question that for Mr. Allen to answer, but I, in my submission, that would be the way that it could be achieved, if I'm wrong, on the European law issue.
So there's a purposive construction to 12 and disapply 17.
Exactly. Indeed, my lord. And those are tools in the toolkit of a member state's court that is trying to ensure that the domestic legislation is consistent with the directive. My lords and my lady, moving on, if I may, to a very short point, which, if I may say so, hasn't been very strongly advanced on my learned friend's part, if I may say so, is the point that we deal with at page 27 of our case, which is that the very fact that Regulation 17 was inserted into the part-time workers regulations as what we in the Court of Appeal have described as a belt and braces provision doesn't mean that one can work backwards from that to assume that absent Regulation 17, the regulations would have applied to judicial office holders. And there is the authority of Walker and Central close, a tax case. But the point in the case, I hope, is set out fairly in the extract that we put, page 27, but just for your note, it's volume 2, tab 37. Yeah. That an argument from redundancy doesn't carry great weight because it's not unusual for Parliament to say expressly what the courts would have inferred anyway. And as we've already respectfully submitted, we say Regulation 12 actually is another example of that.
Well, I mean, the scenario would be Regulation 17 isn't there, but Regulation 12 would be there.
Yes.
The Regulation 12 ordinarily read wouldn't apply.
Yes.
But if you were wrong on the domestic points you've been arguing this afternoon, so that the judge, a part-time judge, was a worker within the meaning of Regulation 12, then then that would also be, he'd also be a worker for the purposes of the directive, and Regulation 17 would have to be disapplied. Is that right?
No. Our next submission would be that if you look at Regulation 17 in the context of the rest of the regulations, what it does is contribute to the definition of worker, so that it's not a carve-out from the meaning of worker, but a building block in the definition of worker in the first place.
Like policemen, police officers.
Yes.
Same thing. I mean, they're treated differently, but that's the same point, really, that they're dealt with specifically.
Yes, yeah, indeed so, exactly so, my lord, and police officers and various other people, so that it's not... My learned friend and I are agreed that the case is not apt for the use of Clause 2.2 of the directive, which allows in certain circumstances casual workers to be excluded. Yes. We agree that we couldn't seek to rely upon that. Where we differ on this point is that we say that actually Regulation 17 is not a question of carving out a group of workers who were within the definition of worker in domestic law. Rather, it is part of the setting of the parameters as to who is and who isn't a worker. And that's it follows from that, if we're right, that it is, and we're wrong on the domestic law points we've been dealing with so far, that we're still right, ultimately, because the domestic law has chosen to exclude judges from the scope of the meaning of workers for the purposes of the implementation of this directive, and that's within the discretion given to the domestic law.
When you use the word judges in that submission, it's judges as defined in Regulation
I'm sorry,
17,
it's
of
judges
course,
as
isn't it?
defined. Quite so.
So they've chosen to exclude certain judges,
Yes.
even though others are not excluded.
Well, yes, indeed. At that time, fee-paid judges meant the same thing as part-time judges because it was the only sort there was. Shortly afterwards, officially, salaried judges came into being. But back in 2000, although there were de facto some judges who, through health or family commitment reasons, were unable to work full-time, who were allowed to continue, there were no part-time judges officially other than fee-paid. There are, as the court's no doubt aware, two main differences, or at least one main difference between part-time salaried judges, part-time fee-paid judges. A part-time salaried judge cannot practice and cannot return to practice. They're in the same position as full-time judges in that regard. So they are actually...
Is there a statutory provision that says that?
I don't think there is, my lord.
No, it's part of the terms and conditions of their appointment.
Yes. Any more than I don't think there's a statutory provision that binds...
And if they're not contractually binding, I wonder how they are binding.
Yes, and
There's always been some debate about this.
There was a chancery judge a couple of years ago who almost tested that, my lord, I think. But there is a convention, a constitutional convention, perhaps is the way of describing it, that applies to permanent full-time judges, that also applies to salaried judges. It follows, therefore, that salaried judges are true part-timers.
This would be an extension of the Constitutional Convention, would it?
Yes. Well, depending on how one looks at it. But in any event, that is, as I'm told, how it works.
This argument could run and run.
It could,
I think it's a side issue.
But I'm sorry, I'm still a bit confused about the role of Regulation 17 and the argument we've been having all afternoon. I mean, on this basis, the argument we've been having all afternoon is irrelevant because you'd be home with, all you have to do is read paragraph 17, that's all there is to it.
Yes.
Is that right?
That's right. My learned friend...
So one would have thought the paragraph 17 be your first point, not yours.
Well,
Because it wins you the day, does it?
I beg your pardon.
It wins you the day.
It does win us the day, but it's just the 5 questions that my learned friend and I crafted a year ago, put it at question 3 rather than question 1, and therefore I've dealt with it in that sequence.
But it does depend upon your view of European law that it is permissible to carve out a particular group of part-time workers, even though you're not carving out the equivalent full-timers for the purposes of the directive.
Yes. Although...
You've got to establish that before you can rely on Regulation 17 by itself.
Yes. Yes. And it complicated by the fact there are no fee-paid full-time judges. But, yeah, my lady's yes. My lady's right, I should say. If we are wrong on the European law point, then to the extent that there is a duty on UK law to find a way that judges are brought within the scope of the implementing legislation, then that must be done.
I see. So Regulation 17 could, in theory at least, satisfy or fail to satisfy the proviso in the cases we've looked at, whereas without Regulation 17, you might be within the proviso.
I suppose so. That's not the way, as I understand it, my learned friend's putting his argument on Regulation 17. Rather, he's saying that Regulation 17 was not part of the process of defining worker. It was saying this is a group of workers that we're now going to exclude, and therefore was a purported exercise of the Clause 2.2 power. And we simply say that that's not right as a matter of legal analysis. But that, as I understand it, is the main thrust.
And if it were right, though, as a matter of legal analysis,
then we couldn't justify it, because not because they're not casual workers, because judges aren't. Clause 2.2 only enables you to exclude casual workers, and judges are not casual workers, and so they don't.
Well, what's a casual worker?
A casual worker is, the classic example in the House of Lords case of Carmichael, are people who show other people around, I think it was Sellafield, it was a power station, and they turn up when they're asked to turn up, and they don't turn up when they're not asked to turn up, and they have no obligation to turn up if they are asked. So it's a very casual relationship. Right?
The 0 hours.
It's effectively a 0 hours contract,
Yeah.
but it's not a 0 hours contract in the negative, with the negative connotations the 0 hours have. It's just a very loose arrangement.
So the structure of 2.2 is wholly different anyway, isn't it? It's got to be with consultation, and the exclusions have to be reviewed,
Yes,
and all that
it's
kind
a
of
very
thing. So
formal
we're
process.
way away from that kind of thing.
Indeed so. It's interesting perhaps, and I know that in the fixed term workers regulations, 2.2 is different. 2.2 is specific to apprenticeships rather than casual workers. So I say it's interesting, it's probably not hugely relevant. But where we do agree is that we do not and cannot and never have attempted to rely in this litigation upon clause 2.2.
And does the fixed term one have the consultation process and the review process as well? So the structure is the same, it's just the particular application is
narrower.
different.
Yes, indeed, my lord. Miles, I think in the 10 minutes or so that are remaining to me, may I deal with the question of the reference?
Yes.
And hand up our suggested question, if the court is minded, to make a reference, and then make some comments on my learned friend's suggested draft, which is at page 97 of his case. Yes, of course. Our question is designed to cover the same ground as my learned friend's question 1. And I can say, since I didn't draft it, that we hope it's a slightly neater way of putting the same point.
Yes.
As regards questions 2 and 3 of my learned friend's formulation on page 97, question 3 we agree drops away because the parties are in agreement that clause 4 of the directive of the framework agreement has direct effect, and that's the subject of recent authority in the impact case. As regards question 2, it seems to us to stray close to a question about clause 2.2. It's our respectful submission, it doesn't really help the matter very much at all. Which is why we've limited ourselves to the one. May we make some observations about the form of the schedule to the order for reference? Which are these, that if the court is minded to make a reference at all, it must follow that the court doesn't think that European law has clarified exactly when and the extent to which you can exclude certain bodies from the definition of worker. And it is apparent in our respectful submission that the court would be guided by some information from the referring court, in particular in relation to the status of judges in domestic law, because that one doesn't know, but it might be regarded as relevant by the court in the reference, and that of course is not something the parties are going to be able to agree, because we disagree as to the status of judges in domestic law.
Well, one of the things that this court has done is to provide its own analysis of the problem and the arguments, sometimes indicating which way its own provisional view lies, and then itself ask the question, or questions, rather than relying on drafts from the parties.
I think certainly in a case like this, where we've heard full argument, I think we would normally set out the competing arguments as part of the background. And as Lady Hale says, sometimes we go further and make, as it were, in effect, a ruling on the domestic aspects of it.
Yes.
And maybe in this case, because of the nature of what we're dealing with, that would be helpful to the court.
In British Airways and Williams, which is mentioned in your cases, this court took that course.
Well, I would respectfully invite the court to take an approach such as that in this case, because the danger, if the court sends a very general question to the Court of Justice, is that the response will be it's a matter for the domestic court.
This would involve deciding the domestic law questions finally between the parties, and then referring the European law questions.
But potentially so, yes. Of course, it's a matter for your lordships and your ladyship.
I follow that, but obviously you have to decide whether to do that or not. But
Indeed so. And it follows that...
Because I can see that if we leave it in limbo as to what the English law position is, then we'll just cause confusion in Luxembourg, which would be undesirable, shall we say.
And particularly if one takes, for example, the Advocate General in Del Cerro Alonso, it might be said saying there's a difference between differences that are substantial between the particular excluded category and everybody else and differences that are formal. It may be that a background of the sort that my lord is referring to might help the Court of Justice to understand what the real issues are in the present case. But the Court doesn't need me to say it's really a matter for this Court rather than me or us to work out the best approach to the drafting of a reference. I do just have a couple of points to make in relation to the schedule of facts, which my learned friend said, I think this morning, were uncontroversial. They're not quite uncontroversial for a number of reasons. If one looks at paragraph 5 on page 99, he cheerfully asserts that a full-time circuit judge's appointment was in the nature of employment and refers, one sees from the footnote, to the letter that we saw yesterday relating to VAT that was written by an official in the Lord Chancellor's Department something over 30 years ago. So we wouldn't be very happy, for the obvious reasons I hope, for an assertion like that to find its way as if it's an agreed fact between the parties. And more generally, we respectfully submit that whilst the schedule goes into the detail of the terms and conditions that are attached to being a recorder, it doesn't say anything about the function of being a judge, the independence that is used in relation to that, and doesn't say anything.
Do you think the judges in Luxembourg don't know that?
Well, if I may say so, that's a fair point, my lady, but if one looks at this schedule, it looks like a list of terms and conditions, and therefore perhaps doesn't quite reflect the shape of the issue that the parties have between them. And another aspect of that, a point that it doesn't mention, is, though it's referred to in the documents in the appendix, is that almost entirely fee-paid judges have another job.
Yes.
They are barristers or solicitors or legal academics.
I suspect that kind of judicial officer is unknown in many of the member states.
Yes.
I was talking actually out to some visitors yesterday who came from various member states, and they were very puzzled by the whole concept of a part-time judge.
Yes.
So, I mean, we may well have to say something about that just to put the thing in proper context.
Yeah, indeed so, my lord. And
do we have any information about the number of fee-paid judicial office holders who do or do not have other employment? That seems to me the sort of information that it's usually rather difficult to get out of people.
Yes. I obviously took instruction, not obviously, but I took instructions on this or asked questions about this in preparation for this hearing, my lady. And what I was told is that insofar as the Ministry of Justice can tell, pretty well everybody has a job doing something else. But there are some people who've retired from full-time practice.
Oh, I'm thinking of the legions of tribunal judges who are women who have no other employment. Legions of them.
Well, my lady, I'm not in a position to give evidence.
Sorry, legion is 1,000 men, isn't it? Sorry, maybe not as many as that, but large numbers. I mean, I number among my personal acquaintance many fee-paid judicial office holders who are women who have no other employment.
Well, my lady, I don't seek from...
And I don't suppose my personal acquaintance is unusual.
No, but what I can't do, my lady, is I'm afraid, give any figures, because as far as I'm aware, there are no figures.
That's...
But there are, as Ms Moore says, limits on the number of days you're supposed to sit as a part-time judge. And the paradigm, of course...
That's not necessarily true in all tribunals.
No, but it is true in the Crown Court.
Yes, but unfortunately this case goes way beyond.
There's a
its
whole
relevance
range
to
of social
recorders.
security tribunals. We're dealing with an area where there probably simply aren't statistics available, actually.
I'm afraid there aren't, and I'm very conscious that I don't want to...
Well, that
You
was
know,
the reason I was
particularly if
asking
they're
the
wrong.
question, because I didn't want us to take your statement
No, and
as
my lady's
being
quite right
a
not
statement
to.
of proven fact, because I'm not sure that it is.
Well, I withdraw it, and I'm sorry that I can't be of any more assistance in relation to that. But many, I suppose I'll stop while I'm ahead, because I was about to say something about the traditional paradigm that full-time judges or permanent judges tend to come from the ranks of fee-paid judges. It's some respects a stepping stone to a permanent judicial or a full-time or salaried or whatever the right description is, judicial position. But I'm trying to be careful that I don't make statements which are simply statements based on assumptions rather than on statistics.
Yes.
My lords and my lady, unless there's anything else, I think I've come in on time.
Thank you very much indeed. Miss Moore, do you have anything to add?
No, I have nothing to add.
Thank you very much.
My lady, before coming to the formal part of the reply, can I just pick up on that last point that was raised about the extent to which part-time judges have alternative employment? We do have the Secretary of the Council of Employment Tribunal judges in the courtroom, and I did just ask him as the question was being posed, and he confirmed, and if I got this wrong, he'll no doubt tell me that it's certainly the case that some part-time judges of employment tribunals will have no or negligible alternative employment. It is also certainly the case that some part-time judges have a portfolio of different part-time jobs.
Yes, quite.
So maybe tribunal judges in the employment sense, and also perhaps members of other parts of the lower tribunal system, dealing with social security matters and so on, or indeed many other different judicial posts. It's also the case, and again this has been confirmed to me from behind, that in some cases, although part-time appointments are taken when individuals are otherwise in full-time professional practice as barristers or solicitors, that part of their work diminishes in their 50s and 60s, and the sitting time increases. So it can be seen as a transitional position, not to full-time judicial appointment, but a transitional position out of professional full-time employment, if that makes sense.
Yes,
So
it certainly does.
people start working, instead of crazy hours as barristers and solicitors, rather reasonable hours as 3-day-a-week employment tribunal judges or something equivalent.
And their private practice simply withers away and they're quite happy to let it go.
So there are a range of different possibilities, all of which, some of which will have, in some cases, some judges will have made active choices. Sometimes, if the career path that they follow through that may be dictated by exigencies of health, demands of caring and so on that lead to these different kinds of approach to it. We certainly would not accept that the current position, or indeed the position for now some years, has been, in the case of recorders, that it is a training post. When assistant recorders were created, that was seen as a training post to determine whether someone should become a full-time recorder. But with the Human Rights Act, that went altogether because it was considered to be inconsistent with Article 6 for judges, as it were, to be on sufferance pending full approval of their appointment. That undermined their independence, and all assistant recorders were automatically made, I believe by Lord Irvine, full recorders. So those are really points of information which I don't believe are in any sense contentious. We don't have the statistics as to this. It would, I think, require a survey to tell you precisely the full figure as to who had filled up their working week with other jobs beyond doing part-time work. We just don't have that. Now, that having been said, I want to follow broadly the course taken by my learned friend in reply. But I want to start with a simple proposition which I do not believe has been addressed or a simple submission which I do not believe has been addressed by my learned friend, which is simply this. Clause 2.1 and Clause 2.2 were part of the same agreement. Clause 2.2 provides for certain types of relationship to be taken out of the scope of the domestic legislation, subject to a control mechanism. It's clear that the control mechanism is somewhat complicated. It is certainly detailed. It's clear also that a similar control mechanism operates in the fixed-term workers' agreement. One can see, for instance, immediately why apprentices should not immediately have a right to extended and repeated contracts of employment, because it's a training contract. An apprenticeship is a fixed-term training contract, and one would not expect them necessarily have the right to go on beyond the training contract. In the context of the Part-Time Workers Directive, this question has to be asked. Is it consistent with 2.2 to say that a state can, purely by reason of its domestic pacification, determine who is and who is not within the scope of the regulations, thereby avoiding altogether the control mechanism in 2.2? We would submit it is self-evidently the case that that cannot be right. There has to be a construction of 2.1 which means that 2.2 cannot be bypassed. What follows from that? It's necessary to find some principle.
Sorry, I'm just trying to follow this through. I mean, obviously, if you took out people working on a casual basis under 2.1, that would defeat 2.2. But 2.2 is targeted very specifically at those particular
at those
kind
who are casual workers,
yes,
and says they can be excluded.
Yes.
But if you could take casual workers out simply by definition in 2.1, so if you simply domestically classified all casual workers as not having employment contracts or employment relations, you could bypass 2.2 altogether.
This is an argument which, in a way, is consistent with the point that I was putting, that the discretion under 2.1 may possibly not extend to excluding part-time workers in a particular type of employment if the full-time workers doing that type of employment
Exactly.
are included.
Yeah.
Because otherwise, why on earth is 2.2 there at all?
Exactly so. So there has to be some principle in play here, which is different in a sense, which gives real meaning to 2.1. Now, this is the point of argument that divides us. And essentially, the argument submitted for the ministry is really as broad as it is deep, based on the Advocate General in Whipple and Peake. It is that there is an unlimited discretion. But one can test that discretion by its application, in this case, in Christie. And you can test it also by reason of the submission that my friend has made. It comes to the same thing. There is no principle that is identifiable within the Christie argument, in Mr. Justice Elias's argument. He simply says it is a small limitation.
Yes.
And that is the beginning and end of it. We said bluntly, whether it's small or large cannot be the relevant point. We do say, as a matter of fact, it's a large number of people, about 8,000 people who are potentially in scope of this limitation on the facts. But there's no principle involved in simply saying it's a small number that are excluded. We say, in short, that actually he's got Whipple and Peake completely wrong. He's construed it completely wrongly. The truth is that Mrs. Whipple was as casual a worker as you could possibly define. She was a 0 hours worker. The remarkable thing was that the Austrian law included her within its concept of employment contract and employment relation, notwithstanding the fact that she had no enforceable rights to work a day under the arrangement that she had with Peake, let alone an hour. If anything, she was a Clause 2 type person, Clause 2.2 type person. So, in short, you're left with this, we submit, on the ministry's submissions. There is no principle that is discernible as to the application of 2.1. There is simply a discretion at large. And we submit that this point is fully rumbled, if I can use that expression, as to its consequences in the discussion first in the Advocate General's opinion in Serro, and then secondly in the conclusions of the court in Serro. We say very shortly in Serro, and I would like to ask you to open it at bundle 3, tab 51, that you cannot answer the reference in the judgment to Kiel
Are we looking at paragraph 12?
29.
29,
in the judgment.
sorry. In the judgment,
Yeah.
yes, of course. Yes.
He cannot answer the reference to Kiel and Jaeger in paragraph 29. The two paragraphs cited by the court, 58 and 59, are the paragraphs which, in relation to the working time directive, say that there is an autonomous meaning of worker. Those are the two paragraphs that are actually cited in Kiel. And to make the point extremely shortly, but it is so terribly important, I hope you'll forgive me for doing that. If you turn to bundle 4 for a moment, keeping that open, and turn to 64. The judgment is at page, the paragraphs are at 1555 through to, 1555. And we see them there, and I invite you just to read them. It is citing 59 in which, in Keele, so in Serro it's citing 58, 59. 59 says, the fact that the definition of the concept of working time refers to national laws or practice does not mean that the member states may unilaterally determine the scope of that concept. Thus, those states may not make subject to any condition the right of employers to have working periods and corresponding rest periods duly taken. So the domestic classification of working time couldn't trump the application of the directive. That is essentially what is being said in Keele, and when applied in Carrow, the domestic classification of the work done by these particular workers in the health service as being regulated couldn't trump the application of the part-time workers regulations.
So what is the extent of the discretion?
I'm sorry.
So what is the extent of the discretion?
Well, in our submission, the extent of the discretion is this, that anybody who would be considered to be a worker in the social policy field, such as working time directive, is within the scope. We see that in the passage which is in 28 in Serro, and the member state can certainly extend it beyond that, but it can't reduce it below it. Paragraph 28, accordingly Directive 99/70 and the Framework Agreement are applicable to all workers providing remunerated services in the context, in that case it was a fixed term employment relationship, this would be a part-time working relationship. And of course employment there is used in the broad sense, which is clear here, working to provide remunerated services. And that's it. So that's why we say that the discretion, if anything, is to include, not to exclude. Otherwise, this simply doesn't make sense. The part-time workers regulation simply doesn't make sense.
To include, you can expand it, you say.
To expand it, yes, but not to diminish it beyond
Or to give it a
that.
meaning it wouldn't otherwise have.
Yes.
Well, it's difficult to get that out of the language of the regulation, isn't it?
Well, my Lord, this comes back really in a sense to the beginning of why we're having this argument. Of course, I accept that reading clause 2.1 as it by itself, without thought as to the whole of the scope of the directive and as to its purpose, would seem to say that, contrary to what Baroness Hare was just saying here, it could on one reading simply say whatever a member state says is an employment contract or an employment relationship is covered, but nothing else. But the effect of that in the Carrow argument was that it was rejected. I mean, that argument, that was what the court did. It simply said that the approach taken by the Supreme Court in Spain, which had ruled, if you remember that set out in the passage in the Advocate General's opinion, the Supreme Court in Spain had ruled, this is paragraph 15, had actually ruled that the ties between these civil servants were not comparable to the status of workers who don't have the status of civil servants. So it was saying it wasn't equivalent to an ordinary working relationship. That was the ruling that had led to the submission by the Supreme Court. But notwithstanding that, and notwithstanding the fact that the Advocate General said perhaps they should look at it again, the court said in terms, no, the part-time workers, in this case the fixed-term workers directive, applies.
But isn't the key to this that you don't just look at 2.1, you also have to look at the recital. And recital 17 in that case was in... I think
16 in ours, yeah.
is precisely the same as 16 in ours. And it's, in fact, it appears as if at the bottom of the page, on page 158 in the judgment of the court in Serro, And indeed they say in paragraph 29, having referred by analogy to Kiel and Pfeffer, and they then says it's clear not only from the third paragraph of so-and-so, but in the light of recital 17 in the preamble to that directive, the member states are required to guarantee the result imposed by community law. So you don't just look at Article 2.1, you have to look, and it so happens that in our case, as in that case, the preamble does tell you you've got to respect the content of the framework agreement.
Exactly. And I mean, I made those submissions just this first thing this morning, but that underpins it. And I'm not going to repeat them, but absolutely is my short answer in response to that. In reply, I'm simply saying the effect of the submissions that you've got from the Minister of Justice, from my friend, really tears that all up and leaves you with no point of principle in terms of determining what's within clause 2.1 beyond what the member state may wish to put within it. And that means that there isn't any kind of uniform level of application of the part-time workers directive. Now, I don't think my reply point is going to get any better, actually, on that, because that really is the heart, we say, the nub of the point. So I'm going to turn, if I may, shortly to look at the problem from the point of view of domestic law rather than the other way around. The reply points really start with that passage in Baroness Hale's judgment in Percy, where she states or quotes a passage from Harvey's Encyclopedia on Employment Law. Let's pull the passage up, if I may, for a moment.
This is volume 224, isn't it?
Yes, I think so. I've got it in our case, if you want to...
It depends which one you're looking at. It's paragraph 141, and it's page 70 in the appeal cases.
Thank you. To... That's it, 141, yes. What we get from that is this. Within at least England and Wales, the position is that the common law has no comprehensive definition of a contract of employment or an employment relationship. The phrase employment relationship is not a legal term of art within domestic law by itself. It's used from time to time. We have an historic concept of a master and servant relationship. We have a contract of employment which can be limited to a contract of service, built on the old concept of master and servant, but can also, in statutory definitions that we've seen and sub-statutory definitions, extend to personally performing work for a person. So it's the contract of services on a personal basis, but not a business basis.
You go back to the Court of Appeal, I think they're saying, well, there isn't a contract. So is contract a term of art in national law?
Well, there's certainly, I think, within the directive, it would have been assumed that the word contract in the directive was the civil law of obligations that was in mind in the European legislators' mind. Whether that would extend to a statutory obligation as opposed to a contractual obligation, I think would be a question that they would find obscure because they've included the words employment relationship immediately following that. We dealt with this point by showing the variety of different connections between judges in the state. If you remember in our case, we cited passages from the European Judicial Network which showed that judges sometimes have contracts of employment and sometimes don't. Sometimes are classed as civil servants and sometimes not, and gave some examples of that in our case. But if I can come back into the domestic context and look at the problem the other way around, one cannot say that there is a single limited concept of employment which necessarily excludes judges. One can put it that way round. You can argue, as it has been argued, that although there's an intention to create legal relations, it's not a contractual relationship. This afternoon that was argued. But that doesn't mean that they necessarily fall out of what must be the concept of employment relations. So it doesn't actually get anywhere to say that there is no contract unless it must necessarily follow that there isn't even an employment relationship, because the directive requires employment relationships as well as contracts of employment to be in scope. Our argument is that there clearly is a contract. We've taken the high ground as our first point, but we're quite happy to win on the second ground. The point that has to be put to you by the Ministry is that although it's acknowledged there are aspects of the relationship which they say is one which is a legal relationship between a judge and the state, it cannot be described in any sense at all as an employment relationship. They have to say that, because otherwise...
No, we're on the English domestic law now, are we?
Yes. They have to say that on their argument. On their argument, they say it's for the state to classify what is a contract of employment or an employment relationship.
But where is the reference to employment relationship in the English domestic law?
There isn't. All that we've got is within the directive. It's for the state to bring within the scope of the regulations or the law that it does to implement the directive all contracts of employment and employment relations.
I think Lord Hoffman used the word legal relationship, didn't he, in Percy?
I'm sorry.
Right?
No. I'm taking two... Let me restart the submission, if I can put it this way. The directive is a direction to the member state to bring within the scope of the transposing legislation all contracts of employment and all employment relationships. That's what it says in 2.1. Now, if you then ask the question, what is a contract of employment? You've got a common law definition, you have statutory definitions, and the statutory definitions extend as far as not just a contract of service, but contracts personally to undertake work or labour. There isn't something that can immediately, you can't look in the books and find out something called an employment relationship, which is different from the idea of a contract of employment. But you can identify that there are work relationships which have the indicia of employment. The examples that were given, for instance, are exactly those that are otherwise covered in Part 4 of the regulations. Army, Crown Service, police, and so on. Those are the ideas of employment relationships. What you would have to conclude is that in no sense could the relationship between the Ministry and the judge, or the Lord Chancellor's Department as it was before, and the judge, be described as either a contract of employment or an employment relationship under domestic law in order to conclude that there was no obligation to transpose the directive in such a way as to cover...
But now we're back to the directive, aren't we? We aren't just construing the regulations, we're back to the directive.
Well, the two join.
Well, they do, I see that. But
The directive tells the state, review your working relationships, identify those which are contracts of employment, identify those which are employment relationships, then transpose the directive through domestic legislation to cover those situations. In order to determine that recorders had no rights under the directive you would have to conclude that the relationship between a judge and the state was neither a contract of employment nor, in any sense, either the historic common law sense or the extended statutory sense, nor even an employment relationship. And our reply to that is, at the very least, it's accepted that there's a legal relationship between judges and the state, and it is accepted that they have many of the indicia of a contract of employment, although it's denied that there is a contract.
Well, time is very nearly up, Mr. Allen.
The points that are made about the content of a contract, duty of fidelity, and so on, statutory disciplinary powers, my lords, we make two short points on that. Many contracts of employment have disciplinary provisions which are statutory. Examples include the health service and indeed firemen. The duties of the contract implied into it will obviously be subservient to the express terms of the contract. Those we think are probably the most important points that need to be addressed. If there is anything else that you would wish me to address, then I will happily do so. The only thing that I would finally add is that Mr. O'Brien has done an assessment of the gender breakdown of circuit judges and recorders. If that's of any assistance to the court, that can be submitted. But I know there have been some issues about the relationship between the two, but that may be a piece of paper too far.
Well, I think you really would have to show that to Mr. Kavanagh, I think, before we send it up. I think we've got really quite a lot of information now, and I think we're also limited, if we were to make a reference, by the court's desire for brevity. There's a limit to how much we can put in.
Could you just bear with me 1 minute? Would you allow me the indulgence? There are 2 points that Mr. O'Brien would be keen for me to state, and I'll take 1 minute. We have set out the other language versions of the directive within our case, and we invite you to recall that before you conclude. And finally, in relation to the VAT argument, our key point is that the way in which the Lord Chancellor's Department historically chose to deal with judges was a choice that it took, and we're entitled, therefore, to pray it in aid.
Very much. Well, I think we're all extremely grateful to Council and to those behind them too for their assistance in this very anxious case. The Court will take time to consider its judgment.